No, so for those of you that haven't seen me speak before, I'm not the most legalistic of presenters, because where I get to is you don't need to know what Section 114 of the Property Occupations Act says or what 123 of the BCCM Act says. That's my job. What you're in is management rights, and there's a whole lot of practical stuff that I think, and I see come across my desk every day, that for me is stuff that people need to know when they're in these industries. And so I look back to when I started in law, so talking to Liz Lavender, so I started here on the Gold Coast in January 1992, became a partner in 2002, and I had absolutely no idea about the business of law. I knew a bit about law, I knew a bit about body corporate and management rights, but in terms of actually running a business, I had no idea whatsoever. So for me, this session, when Kelly emailed me, 8 weeks ago, and we picked a date, then suddenly we're here. I did the slides on the weekend. For me, it's really about some of the things that you might not necessarily know that you should. And so if I had the technical capability, I would have actually got this up from Google. So, and I'll talk you through this slide. For those of you that have seen me speak, I talk more to pictures. If you want to Google this afterwards, it's Donald Rumsfeld, pre-Gulf War. So in a press conference, he says, reports that say that something hasn't happened are always interesting to me, because as we know, there are known knowns. There are things we know that we know. Now bear with me on this, because the first time you hear this, it sounds like absolute gobbledygook. But when you talk about known knowns in the context of business, and in particularly in management rights, what we know is that we need to be licensed. We know that we need audits. They're things that we understand. Very simple. You move on to the next part of his press conference. We also know that there are known unknowns. That is to say, we know there are some things that we do not know. So again, in that same example, we know we've got to be licensed. We know we need to have audits. What happens if we don't? We know that there are going to be consequences, but we don't know what those consequences are actually going to be. So that might be fair trading jumping down your throat. It might be you skate away unscathed for a whole period of time, and today will be peppered with war stories from clients, because this whole presentation is based on things that come across my desk. So clients don't ring me to say, Frank, we had a really great month, we picked up 2 management appointments, the committee's great, we made lots of money, our capital values increased, just letting you know. That's not what clients do. Clients ring me when they've got issues. And so those issues for me a lot of those known unknowns, and then the last one, but there are also unknown unknowns, the ones we don't know we don't know. Now those are the things that come from left field that take us out in the context we didn't even know it was a risk. We didn't know it might happen. And today, as Rumsfeld finishes, if we look through the history of our country and other free countries, it's the latter category that tend to be the difficult ones. And that's what I'm trying to do for you today. So when you walk out of here today, in your world, there's a lot of known knowns, there's probably a lot of known unknowns, and there's also probably a lot of unknown unknowns. So I would like you to walk out of here today, and also the people that will eventually watch this because we're recording it, of being more aware of those things. And again, like I said, that's not sections of legislation, that's actual business operations in a management rights context. And you can learn from, I suppose, the unfortunate experiences of other management rights clients I've had over the decades. Because the reality is, all of these war stories that I'll give you today are real. And they actually happened. That could have been at any stage. 1 or 2 of you might know the characters in them, I'm not naming names. And for me, those unknown unknowns are the most critical thing. So one of the things that I do from a legal perspective is I've got a bunch of legal mates, one of which is Col Myers. Some of you probably might have him as your lawyer. He's been around for a long time. He's 20 odd years older than me. We catch up for lunch once every 3 to 6 months, and all we do is talk about what's going on. Again, we're not talking about Section 120 of the BCCM Act. We're talking about the business operations and what we're dealing with on a day-to-day basis, because it changes. And that's how I keep myself in the loop to a degree with what's going on. And for you, I want to take you through some of those today. So the other part of this is risk. Because the reality is that when we've got a known unknown, the fact that it's unknown means there's an element of risk to it. So, I mean, purely from a definitional perspective, risk is the potential for uncontrolled loss of something of value. So you immediately think about financial, that might be money, but it can also be emotional stability, it can also be reputational harm, it can be anything of value to you individually. So as I'm going through these things today, I'm talking about really the intentional interaction with uncertainty. So again, if we choose not to go and get licensed, we choose not to renew our licence with fair trading, we are moving in to an uncertain environment. What is going to happen? And again, fair trading might come after you, owners might terminate letting appointments, your body corporate might run you over because your letting agreement includes an obligation to be licensed in accordance with law, and you are then not licensed in accordance with law. So that's the uncertainty that you're then interacting with. So uncertainty is unpredictable and it's uncontrollable. And the risk or the action you take in despite of that is your assumption of risk. And the last thing for me that's really important is the perception of risk is very subjective. So what might be risky for me might not be risky for you. And to me, that subjective judgment really comes more than anything else from prior bitter experience. And again, I go back to when I started as a partner in the law firm, so 17 years ago, and I look at some of the things we did then, and I would sit here and look at them now with absolute horror and say, what on earth did you do that for? And somehow we skated through. And for me, I survived those unknown unknowns. From a management rights perspective, and I'll give you a simple example. No, actually I'll save that, but that's what I'm talking about. So it's really that reaction with risk. Now, is Chris Trail here? Christopher, cool. So I am going to, Chris Trail is with EBM, and I've invited him here today because he's an insurance broker, 11-year sponsor with ORAMA, specific management rights policy, because I think for those of you that don't have insurance, you should be talking to him after this event. And I'll tell you why. Because a lot of people don't understand how insurance actually works in these things. So I suppose where I get to from a business perspective, the best way to manage risk is obviously know what risks you are running and to have good systems and processes. If your operations are tight, you're using the right software, you have the right team around you, you have checklists, you have calendar entries, you have a program, you understand what's going on with your committee, your life is going to be a whole lot simpler. You understand what it is that you need to do. So good business operations help reduce risk a lot. The second part is structuring. So from my end, it's probably a bit late for all of you if you're in management rights now, you own what you own in the entities that you own, but in simple terms, that might be as vanilla as owning the management unit which you're living in your own names, and it might be setting up the business in a company as trustee of a trust. So what that does is separate some of the risk. So from a pure business perspective, management rights is not an inherently risky business. We don't get management rights operators sued regularly. In fact, it's pretty uncommon in my experience because there's not a whole lot of liability that sometimes accrues from these things. And it's completely different to my business. So from my business, if I'm acting for you when you buy your management rights business, and I tell you that your management rights agreements are right, and it turns out they're not, then what you paid for that business is gone. So every day that I do a management rights due diligence, I've got to be 100% certain that it's right, because if I'm not, I'm on the hook. So that's the advice type of thing that we give. So from an insurance perspective, there's really three types that I want to briefly cover today, and I'm not, again, giving you advice you need these things. I don't have an AFSL, but it's something you all need to be aware of. So public liability is effectively trip and fall inside your own property. Someone comes into your unit, your office, trips and falls, public liability, that normally attaches to your contents policy. So most of you will have that. The last two are the things that people sometimes don't get. So professional indemnity is really cover for negligence. So negligence in its simplest form is you owe a duty of care to someone, you breach that duty of care, and loss or damage is suffered as a result by that person. So in a management rights context, the simplest example is going to be part of your role is making sure the tiles are kept clean every day in the foyer. You're down there one day doing that, you're using soapy water, someone comes and trips and falls on their backside, break their tailbone. From an insurance perspective, the body corporate's public liability policy covers it from that trip and fall, because it happened on its common property, Where you will get dragged into it is from that professional indemnity perspective, in terms of you were doing your job and someone has suffered loss as a result because they've broken their tailbone. What happens is that you get dragged into that claim then for damages, and that's what that professional indemnity insurance covers. So on the caretaking side of things, the other side of things is obviously letting. There's probably not as much risk in letting as there is in sales. So if you are giving advice, and I'll talk about this a little bit later on as well, you need to make sure you've got the right level of cover. And I know that, yes, it costs money, but I can guarantee you that it will cost a hell of a lot less than the day you get the personal injuries proceedings notice in the mail and you ring me and say, Frank, what do I do with this? And I would say, go to your insurer. And you say to me, I don't have insurance. I said, well, put your stack hat on because this is about to get expensive. So just because your house didn't burn down last year doesn't mean you shouldn't have insurance for the next year. And the other thing that happens with that is runoff cover. So, and again, war stories. Had 2 clients who sold management rights, happily ran them, permanent buildings. One was 2 years, one was 18 months after settlement. They get one of these notices. Hey, you have been negligent, we're going to hold you to account. And both of those related to accidents inside units that they were managing for people while they owned the management rights business, and the tenants hurt themselves. Both times tenants fell downstairs. Now, it might be that the tenant was drunk, but what that doesn't stop is them potentially bringing that proceeding. Because what's happened is the tenants hurt themselves, they've brought a proceeding against, or they've given notice to the lot owner that I got hurt in your property. Owners hopefully got public liability policy. And the owner says, well, or the owner gets legal advice, or the owner's insurer says, well, we had that managed by so-and-so. So if there was something going wrong in the property that hadn't been done the right way, then the manager's the one who's actually got to be accountable for that. So the manager then gets dragged into it, and that happens after they've sold. So one of the things you need to do if you've got professional indemnity is make sure that you have runoff cover, which gets cheaper year after year, for any claims that might have happened during your tenure that you weren't aware of when you sold. And the last one is body corporate disputes. And this is where, and I'll declare my conflict in a sense here, EBM has a specific policy that gives you insurance if you get a remedial action notice from your body corporate. And they've also now got an add-on to that policy where if you think you're about to have a dispute with your body corporate, you can make a claim in terms of their insurance, or you go to EBM, make the claim, and then at this point in time you get a choice of one, which means you get to use us as your lawyers to help navigate that thing at EBM's expense, or the insurer's expense. So again, from a management of risk perspective, insurers understand risk. That's what they price. You pay the premium in exchange for them assuming some of your risk. That risk is defined in the policies, and you can obviously have more than just that, and I'll talk about some of those on the way through. So Chris, if I get to one of these slides and I haven't mentioned that you can insure for it, just raise your hand. So you've really got a smorgasbord of insurance options, and my recommendation to every management rights client is you should have this. And just because it hasn't happened to you doesn't mean it won't. And that's what insurance covers. So in terms of some of the specific stuff that we're talking about today, and legislation I would call a known unknown. For those of you that haven't been living under a rock, we've actually got a whole bunch of legislative reform on the horizon. So from my perspective, in a management rights sense, you can't control what that is. You can engage with your parliamentarians, and to be honest, we've probably been involved in legislation changing 3 times. Twice it was a result of loopholes we found in the legislation, took advantage of, and they shut them. And one other was when they were changing lot entitlements. We had one client with a very specific submission that allowed them to get their change through before they shut the door, which was in 2011. So it's a really unique and hard thing to do. But from a legislative perspective, knowing that things change, what do we actually do about it? So for me, the first thing is to understand it. Because you're in the business of providing advice to your clients. That bottom one there on that slide says join ARAMA, and I feel even more strongly about this after what we've just been through. So for those of you that don't know, ARAMA is the peak management rights body. It represents just the interests of resident managers. It doesn't fight for anyone else. So I'm one of the panel lawyers for ORAMA and have been for 10 or 12 years, and actually had the joy of sitting with government talking about changes to legislation. So from a lawyer's perspective, you sit there, you study these things, and I'd never really thought about the process of creating legislation. So where we'd got to was the government had the recommendations from QUT for the draft modules we've got now. They'd come up with a 53-page document of recommendation, our thoughts, or government thoughts, why we might or might not do that. And then they were basically, we had a representative of the Attorney General, Director General of the Justice Department, and 3 pointy-head lawyers that actually draft laws. So it's a breed of lawyers that just sit in back rooms and draft legislation, which is extraordinary. And then unit owners, people, SCA, and myself and Trevor Rawnsey for ORAMA. And what we did then for 3 hours was run through these things and talk about what would actually happen. So from a management rights perspective, there is basically nothing in those new modules that affects resident managers. Nothing of any substance whatsoever. And you may say, well, so what? The reason for me to join ORAMA is that ORAMA's representation at that table has meant that there is nothing negative in that legislation that affects resident managers, because it's very easy for that to happen if you're not in the room. So when you look at what those modules were, body corporate managers copped a bit of a tickle up about insurance. So they're going to have a whole lot more disclosure about insurance. Property developers who didn't have representation in that room have effectively been lumped with a whole bunch of additional compliance that they're not even aware of yet. And that's what they get for not showing up. But from a management rights perspective, it went through fine. The other thing that we've got now is this rental law reform. So for those of you, hopefully you all get my newsletters. If you don't, there's obviously subscription forms in that material to get it. This will be relatively big from a property management perspective. And in this one, the interests of the REIQ and ORAMA representing property managers are identical. What the government's doing is it's a really left-right ideological type thing where tenants are going to have a bunch of additional rights. And for me, probably the standout is effectively tenants are going to have the rights to bring pets into properties regardless of whether the landlord likes it or not. And that is more than likely going to become law. So in a body corporate sense, I don't think government has quite understood how emotive pets can be for bodies corporate. So from a owner-occupier's perspective at the moment, there's no such thing as a pet-free building, but from a lot owner investor perspective, today they have an absolute right to say, I don't want pets, and then pets are prohibited. That will change. That will absolutely change. So what's going to happen is, short of there being some genuine reason for an owner saying, I don't want a pet in my property, and that has to be more than, I don't like it, some health or safety reason, I suspect what's going to happen is you guys as property managers are going to be required to say to tenants when they make applications is you can bring a pet. The way I read the regulatory impact statement, that's the way the government's going to go. Again, detail is yet to be seen. When it does come out in the Residential Tenancies and Room in Accommodation Act, obviously there'll be a whole bunch of information around that. But from my perspective, from a management rights point of view, what we all need to be doing is starting to manage our owners about that now. Because the last time, or the first time you have that conversation does not want to be when you've got the application for the new tenancy and they're bringing their Great Dane and the owner's had a specific anti-pet policy their entire life and you've got to tell them you can't say no. You need to start managing that now. And by now, I should reframe that. Once we actually see the draft legislation, let's get the detail right and then go from there. But from a management rights perspective, that can then become a known known. So you're not having these fights individually with people day by day. You've told them all, you can refer back to the content, here it is, and really sorry, but that's the law. Got no choice. The other thing that absolutely will be coming for property managers or licensees is what they're calling CTE, Continuing Training and Education. You guys are all going to have to do 10 hours worth of CPD a year to keep your licence. That's not law yet, but that is absolutely on the agenda for the next 6 months. And I don't think that's a bad thing. Whether, and I suppose it'll be interesting to see whether something like this will qualify, because to me this is well and truly training, but that's another change. So these things are continuing to come. and you need to be aware of them, you need to stay on top of them. And you need to manage your owners around them to make your lives easier. Like I said, you don't want to be having those fights at the death. So that's from a legislative perspective. Next one, borrowing. So if you are one of the rare managers who doesn't have any debt, happy days, you can switch off for this particular slide. If you're like the rest of us and you do have debt, then I think you need to switch in, because this is actually really interesting. And probably 10 years ago, we were just sliding into the GFC. You know, and at that stage, I was down here on the Gold Coast, up through 2008, it was easy, and ever since then, it has been a whole lot harder. So, and I don't, you know, it is never different this time, but this time it has been a lot different from a banking perspective, where banks haven't been sinking people. And that's because of the Royal Commission, APRA, whatever it might be. Maybe the banks realise they have written bad loans and therefore can't be going and getting after people. And what that has led to, in my experience at the moment, is the newest special condition we've had to draft for management rights contracts to keep on tap is a condition that makes the contract subject to us going to the bank to ensure that the bank will release for less than what they were owed before the buyer starts doing due diligence. So, and the worst example of that I've got at the moment is a client borrowed 2.2 and they're under contract at 1.7, 4 years ago. And you can appreciate they put a whole lot of equity in that has gone. So for me, that the bank's wearing it, we've convinced them that's the value, and realistically, if the bank had have done what was happening, or what should have happened, is that particular client probably should have been taken out of that business 2.5, 3 years ago, because at that point in time they weren't capable of running it. And all the bank has done by letting it go is cause everyone more pain. Bank included, our client included. They're going to walk out with nothing, have the bank potentially after them for $500,000, and that's when we have the fight about you shouldn't have lent the money to us in the first place. That's a very ugly process. But from a debt perspective, so for me, some of the, these will be known unknowns or unknown unknowns, is your level of gearing is a really important thing. Because what happened in the GFC for me, and that's really tied in with our loans indefinite, I'll start with that actually. When you go and buy a piece of residential property, the bank will give you a 30-year loan. If it's on P&I, they basically never look at you again. You pay it off, you're done. If you're on interest only, maybe after 5 years, they take you off interest only, put you on P&I, but they never go and review the valuation, look at your serviceability. That's just the way the system works. That's not the case with commercial money. So when you buy a management rights business, you might have a 25-year term, they might give you a 15-year loan, they might make it interest only for 2 or 3 years. But after that 2 or 3 years, the bank, in theory, under the terms of their loan offer, has the ability to say to you, we'd like our money back, thanks. Or we're going to change your LVR from 70% back to 60, because that's our new policy. Or we're going to require a valuation, and we're going to change your LVR. So at the same time, if the valuations, and this was GFC, banks, one bank in particular would lend at 75%, it decided to ratchet everything back to 70, and it required valuations on everything. All the values had fallen, so you have a double whammy. And suddenly, you've got an obligation to repay your bank, or get charged turbo rates of interest, or go on a very aggressive P&I program for a couple of years that sucks up all your cash flow. So for me, you need to be aware that your loans have a definite time frame. And I think the thing to do is to go and look at your letters of offer from your bank. So if you've bought your management rights business or you refinance, there's going to be a written document there from your bank saying we're going to give you X dollars, X rates, X terms and conditions, and this is when we're next going to look at it. And that'll usually be subject to where you're at, 2 to 3 years, maybe 4, maybe 5 if you're really lucky, but it's very rare to see those. Most of them are reviewable about the 3-year mark. So for me, you want to know when that is. And the other thing you want to know is what conditions the bank is going to have in relation to that review. So, and I recognise when you're buying a management rights business, you've got verification reports, you've got due diligence, you've got letters of offer, you've got resume and references and body corporate approval and moving house and all that sort of stuff. So there's paperwork everywhere. So it's very easy not to see this stuff. I get that. But your letter of offer will more than likely have a bunch of conditions subsequent in it. So there's conditions precedent, so we need to make sure that the property's insured, we need to make sure we've got a valuation, whatever it might be. Those all get ticked off before you settle. The conditions subsequent might include things about interest rate cover, your level of gearing, LVRs, might include that you haven't lost more than 10% of your letting appointments. Whatever they are, you want to know what they are, you want to know when that date is, and you want to make sure you're in front of that conversation before you get the tap on the shoulder from the bank, because they are becoming very religious about following it up. In this environment, they're making sure that they all tick their boxes, and one of those boxes is when loans expire. And if there is an issue, you want to get in front of it. And that's not when you've been tapped on the shoulder, that is 3 to 6 months beforehand. The other thing is that very last point there is, can you be a friend with banks? And the answer is absolutely not. You cannot trust them. And that is also GFC experience. So, and in a simple version, what banks do is that person on the front desk, their job is to give you money. They're marked on it, they've got KPIs on it. If they're not making loans, they get sacked. So when you're talking to that guy or girl on the front desk, they want to give you that money. What's behind the scenes is credit. And credit is the one who makes the decision about whether you are going to get that money, and if so, on what terms. You never see the credit people. So what happens in bank land is that if your loan goes bad, the first thing that happens is the person on the front desk you never speak to again. They get locked out of the system. They physically are removed from the ability to see what's going on. Because the banks understand that you might have a personal relationship with that person may want to help you, they shut them down. And you get to deal with someone in recoveries, in surgery, as ANZ calls it, bad bank, which is what NAB calls it. You go to Brisbane, you deal with someone in a grey cardigan, or that bad loan I've got at the moment, I'm dealing with someone out of Sydney. That's how far removed they've got it. Who doesn't even understand management rights. I'm having to educate her about it. So you cannot trust whatever they're saying to you on the ground, because that person may not be there to say it to you in due course. So don't, it's wonderful to have a good relationship with your banker, and that is to be fostered, but don't think they're going to be there if times turn tough, because banks know that that's not the way it works. You'll be dealing with someone else. And the day to be frightened in that one is when that someone else emails you and says, hey, I've now got responsibility for your loan. And usually that's not a surprise. At that stage, you've been in arrears, you haven't been making payments, your LVR's untidy, whatever it is. You'll know that there's a financial circumstance that the bank's not happy about. And for me, the biggest red flag with banks is not giving them what they want when they ask for it, particularly around tax. You don't give them your tax returns, that is the number one red flag. Because lots of people don't pay tax. And if you're not clearing, you're not saying to them you've paid your tax, that's almost instantaneously in this environment, you go to bad bank. So make sure you're on top of that. I go that way. Litigation, favourites. Now, some of you who will have been, so I think this is the fourth one of these we've done, Scott. We've done deal killers in management rights, done marketing yourself in management rights, and we've also done solving management rights disputes. So there's a bit of overlap with these, so I'm not going to repeat ad nauseum what I did in each of those. So there's a couple of hints in here in the slides. For me, if you're interested and haven't got this particular presentation, I'll send it through to you afterwards. You just need to email me. But litigation is bloody horrific. So if you're talking about interaction with uncertainty, that is what this is. And it is uncontrollable uncertainty. And from a litigious perspective, obviously, I've acted for lots of clients in disputes. As happens in business, I've been involved in some myself, and it is a lucky dip. It really is. You're not in control of the process. You are punched around by whatever the other side does or doesn't do. There's a lot of latitude about how they do it. They might be completely and utterly unreasonable, but there's a court system. And more than anything else, at the end of the day, if it goes the distance, it's going to be horribly expensive. You're going to lose lots of sleep. You're going to be particularly stressed, and you don't know what the outcome's going to be. Because at the end of the day, it's going to be plaintiff, defendant, judge. And the judge is going to make a decision based on the arguments from either side, and that judge's decision is going to be random. Some of them you can feel good about, but I know I've walked into litigation thinking we're going to win, and we lose, and thinking we're going to lose, and we win. And I'm in the game. And I think I get a lot of the issues. And part of the difficulty with litigation is you don't necessarily know all of the bits and pieces that are going to come out of it. There might be one particular bit of evidence that you've forgotten about that the other side finds 6 months into the proceedings that completely sinks your case. That's what discovery's about. The really bad ones are the ones where it's a question of he said, she said. So if you're arguing matters of law, what does a section of the Act mean? Then there might be some precedent around that and that sort of thing. If you're arguing matters of fact, verbal altercations, was this duty particularly done, and it comes down to questions of credibility in terms of who does the judge believe, that is random because it depends on how good everyone is on the stand, and you never know because that is a pressure cooker environment. So for me, litigation, ideally, and that's sometimes you have no choice, don't get me wrong, but for me, litigation should be a means to an end. It shouldn't be the end in itself. So your overall strategy for me in any piece of litigation, I give this to clients all the time, is that it should try to get you to the stage where you can agree a negotiated outcome. Because at that stage, you're in control of the decision. You're not leaving it in the hands of a third party. You can cut that off, and sometimes it takes a little bit of conditioning of everyone to get there. So, first war story today in relation to this, in a management rights sense, obviously always relates to remedial action notices. And what we had, this client had been in their business for a very long time. New committee came in, very old school management rights agreement, mow lawn, no specifications, none of that sort of stuff, very generic duties, salary that increased over time, and a stroppy committee that was deciding that they didn't like management rights, but we still had 20 odd years to go. So they engaged, or the body corporate engaged, a lawyer who's fairly notorious for punching on regardless, and where that had got to for working for the manager was, from a client perspective, is we need to sit down with these guys so I can see the whites of their eyes and tell them what's going to happen. Because one of the difficulties in a legal sense, and believe it or not, is that when I'm acting for you, you're effectively actually my legal property. No other lawyers can communicate with you on the other side of a transaction without my express consent. Can't talk to you, can't email you, can't write you, can't call you. And for some of you who might get frustrated with matters from time to time, you might try to ring the other side's lawyer. The first thing they'll do is say, really sorry, I can't speak to you, and hang up. That's the way it works. So, but in a mediation, what happens is that there's a mediator. Usually the way it works is everyone gets to sit around the table at the start. Mediator says, sets the scene. Each side gets to have a say. Then you break up into separate rooms and try to sort something out. So this one was the only one where I knew the committee wasn't going to get the right advice in terms of how long and drawn out this would be, because the reality is we were fighting for our business and our investment in our future. The committee's fighting to save themselves $10 a week. And they're doing it on a voluntary basis. So their motivation at the start might be right, but over time is going to get ground down like you would not believe. So I needed to get to the stage where we were in the same room and I could actually look at them and say, you know what, this is what's going to happen. That's what I did. Now that didn't settle that day, but it did settle 2 months later. What it did was start that conversation where everyone realised we all had something to lose and we needed a way to get there. So that was the way in that one to avoid litigation, because the alternative was they issue a remedial action notice, we contest the fact that it's not valid, it's not enforceable, these duties aren't there, whatever. They say rubbish, they call a general meeting, 21 days notice to terminate us, we file a QCAT proceeding to injunct them from doing that, and 18 months later we get a decision. All bad. That one sorted itself out. So, and even now, there's one that's just come out, it's been a 4-year bit of litigation. The manager ended up winning, and I saw the other day the cost decision. The manager got awarded 200 grand costs from the body corporate, but the manager spent 800 grand defending themselves or prosecuting that proceeding. So even though the manager won, they're still out 600. Now I'd have to think there were some other alternatives there along the way through. I wasn't involved in it, so I can sit here and throw stones from the sideline as much as I like, but whether that had been tried, I don't know. And that's the reality of, we don't get involved in lots of QCAT disputes because that's how we tend to solve them. Great for the clients, not good for us from a business perspective, but that's the way it should be. Yeah, I'm very unpredictable. It's not LA law. Someone keeps telling me Suits is the thing I need to watch from a lawyer's perspective. I watched one episode and I thought it was complete rubbish. And it must have been the worst one ever. And I tell this story where the firm had two clients that were bluing. Big whatever firm they are in New York. So client A, client B, they've both got their lawyer representatives. And the partners say to these guys, okay, here it is, whoever wins gets partnership. Which is just so unrealistic, it's not funny. Because what you're going to do is absolutely torch one of the client relationships, which is not what you're doing. You refer them both away. Anyway, so I thought, I'm happy to live in some form of fantasy land, but not that ridiculous fantasy land. Next thing, committee. Now, marketing yourself in management rights has a whole lot more detail on this, but these are the most important people in your management rights relationships. You need to make them known knowns. You need to know who they are. You need to know what they want. You need to know how dictatorial or authoritative or passive they're going to be. And you need to roll with those punches. The reality is that what you are to your body corporate is a service contractor. You provide the same services that I do when we're acting for a body corporate. The difference is you have a long-term caretaking agreement, et cetera, et cetera, et cetera. I'm going to be engaged for a specific piece of work to do the bylaws. That's it. But the committee, inside that framework of our engagement, will give us instructions. And that is the same with you. So I think that third point there is really important. I've got a couple of clients going through this at the moment, the danger of long-term tenure. So, and it really, one of the difficulties with marketing to management rights, and I suppose I should give a shout out to our new CEO, Airlie McLaughlin at the back corner here, who's starting to understand what this whole industry is about. One of the dangers, and she's asking me, how do we find all these people? How do we know who they are? Where do we get the information in relation to them? There is no database. There is no record. And I suppose, Liz, you'd remember that from back in the day. You're prospecting by door knocking. So you don't know how many of these businesses there actually are, and as a result, we don't know the average turnover rates and that sort of thing, how long people last, etc. in management rights. I mean, and 10 years yesterday, there you go. Congratulations. Long service leave if you're an employee. But you're not. So what happens is when clients do spend a long time in their business, that's usually because they've got a good committee and a good strata manager and everyone fumbles their way into the way it should work. There's a natural sort of relationship where everyone knows what everyone does. There's no worries about it. The manager spends what they want to spend, they get reimbursed, and it trundles along happily. What happens though, eventually, is that committee, people sell, people move on, they decide they want to give someone else a go, whatever it might be, and new people come in. And those new people have absolutely no idea what the previous arrangement was, or how it was operating, or in fact, they might be coming in, particularly if they're accountants, with a specific idea of cutting costs, because that's what bean counters do. And the first thing they do is say to you, you know what, your spending limit's going back to zero. I've had so many conversations about that over my years, it's not funny. And yes, your caretaking agreement may say that you can spend up to $300 in any single circumstance to get consumables for the body corporate. And my response every time to my clients when they say, but that's what my agreement says, you seriously should not have a fight with your committee about $300 worth of expenditure. You're going to bust that on me before you blink. So the reality is, where you need to go, you need to start to roll with that new arrangement. You need to build trust with those people to get them to know that you're not rorting them. And that's not to say that you are, but that's the impression some people have, and some people want cost control. So you've got to get to the same stage where hopefully I get to with clients, is you don't ring me for a quick chat, then I send you a bill the next day and there's $500. It's when you need to do something, you'd write to your treasurer and say, hey, I need to go and get $100 worth of petrol. Are you cool with that? Yes, I am. And you front manage the costs. And the danger with long-term tenure is recognising that when a new committee comes in, you may need to reset the way it is you're doing things, particularly if you've been there for a long time. The other one, I have the dispute of not dispute. Clients getting upset about the body corporate mailbox. I've been doing the body corporate mailbox, but it's the body corporate's mailbox. If they want the key, let them have the key. If something gets served on the body corporate and the body corporate doesn't act on it, that's the body corporate's problem then, not yours. But I've always done it this way, it doesn't matter. So remembering that you are a creature of instruction, you need to be friends with your committee where at all possible. And that's not to say we're going to be friends with everyone. It doesn't mean you're having Christmas Day with them. You need to have a relationship with them. It needs to be courteous. You need to be professional. And you need to recognise how much grief they can cause you. You get them offside, it's just not a good place to be. So in every element of business, and don't get me wrong, I mean, we act for some people who I just don't like. You know, at the end of the day, they'll pay the bills, that's my business. It might have been referred to me by someone who I've got to look after, and I do the job. I say I enjoy it, but that's the sandwich I have to eat, and you guys sometimes need to be the same. So, and that's not to say you can't do anything about it if there's extreme grief, and regime change is that. So every year the committee goes at the AGM. If needs be, you can accelerate that by requisitioning EGMs and the rest of it. But the biggest difficulty with that is not the legal process, it's finding other people to put their hands up to replace those. Because instantaneously you create an us and them mentality. You've resold the chairperson, and you know, that does start the fight, but sometimes that's where you need to get to. So again, from a strategic perspective, where are we going? What are our tactical ways to get there? So when clients ring me with committee disputes, there's a bit of a interrogation there about what's caused it, where things were, and ultimately sometimes where we need to roll over and not have these fights. Let them have that. It doesn't matter. You know, you've got better things to do than be talking to me. All right, keep putting backwards, and that will go. There we go. Strata manager. Now, I've spoken about these guys and largely girls, so that probably would be the typical strata manager on a Monday morning. If you think your life can be pain, you've got to appreciate what happens to these people. You have potentially one, maybe a couple of management rights businesses, 2 or 3 committees you deal with. You might have 100 owners that might email you. These people have 80 buildings and 80 committees and 2,500 lot owners who don't understand a single thing about what they do. So they come in on Monday morning to emails, to abuse, to whatever it might be, stupid questions. Why do I have to pay levies? I want to take myself out of the body corporate. You guys are taking stuff on the side. All that stuff is all they wear. So the very simple rule I have for strata managers, and it's certainly what our business operations do, is you want to make their job as easy as possible. So you don't want these people to be an unknown known. You want them to be a known known. So you do what it is that they ask you to do. You manage them. You make their life easy. You become the very least of their problems because they have a lot of problems. They really do. And if you're the one that is making them seamlessly work with that building, they will look after you. And that's not to say that they're going to go and do something unethical, they're going to tell you something outside the scope of what their duties are, etc., etc. If you come back to that mediation story I was telling before, I knew the strata manager on that building. I've known him for 20 years. I suppose that's the joy. He knew that what I was trying to do was the right thing. And without doubt, he's helped get the committee across the line to that mediation. Because again, in his world, the last thing he needs to be involved is a QCAT dispute. More dispute, more lot owners, more special levies, more grief. It's not in his interest to have that. But imagine if he wanted to cause grief to our guy. His role under his contract is levies, administration, etc., etc. Imagine if he ran dead on the committee and just let the lawyer take complete control over what was happening. Or imagine even worse, he said, you know what, you really should go after this guy, he's due it. That can happen. And if we had been really difficult to him, it's a possibility. So those little things, and that's not, that they can influence committees. And if you are easy to deal with, you look after them, you make their job easier, and ideally, you do drop them a bottle of wine at Christmas time and say thank you. You do shout them a coffee or a muffin at some stage after a general meeting. Whatever it might be, if you have a personal relationship with these people, it becomes a whole lot easier. So, I mean, how much easier is it, when I suppose reframe that, it's a lot easier to fire nasty emails at people you've never met than it is to fire them at people you have met. And the same applies to you. And that's the same with your committee. Keyboard warriors abound. That's just the way we are. It's not going to change. So the more you have personal relationships with these people, the easier your life is going to be. Next one is owners. Now I did a whole seminar on this. That's that marketing yourself in management rights. What you should do, if you haven't watched that, is read that. And to be honest, one of the things that Airlie and I will be doing is next year, I think we've probably got some relatively exciting changes coming in terms of the services we're offering resident managers, and this will be part of it, in terms of actually helping manage the relationships with owners. And note there I've said owners, I haven't said investors. Owners as a whole are where you need to focus your efforts. Your investors are absolutely important, don't get me wrong, but the reality is that over time, they're going to come and go. They are going to sell their properties, whether they want to or not. They might get mortgagees sold, they find another investment, they're retiring, they're downsizing, they're doing whatever. They need money to go and to do whatever it is that they're doing. So you are going to have turnover in your rental pool. The rest of the owners are the ones who will replace those. So you need to have relationships with all of those people. So that was an hour and a half, that session. You need to make, again, to the greatest possible degree, all of those people known knowns. You know, it scares me a little bit when you know, how many owners have you got? 100, how many in rental pool? Oh, maybe 40. How many outside agents? Don't know. So we've got 60 potential clients sitting there that we're not communicating with. We need to be communicating with those people because they are the replacements. And they are also the relationship we have that gets us topped up, that saves body corporate disputes, that brings in regime change when we need to actually get rid of this absolute idiot chairperson because all he's going to do is rack up a bunch of legal costs having an argument about a remedial action notice. They're really important people in our lives. Letting appointments. So we'll get legal for a little bit here, and probably in terms of issues we're having on management rights sales at the moment, this would be the bulk of them. So, talking to Herb before, I wish I knew what made people transact, because I could build a business around it. We go through periods where the phone doesn't ring for a week, and at that stage, that's where I ring Col Myers, say, mate, are you the same? Yes, I am. Okay, cool. And then every new phone call is a new deal. It's just random. So at the moment, we're in a really, really busy settlement period, and that's for deals that, you know, were contracted 2 and 3 months ago. I think we're probably, in relative terms, as busy as we've ever been. This is December 2019, and we're looking pretty solid through February, March, so I don't know what that is. But in terms of the issues on transactions, it is these. Legal due diligence, we can always usually get around whatever the problems are. Finance, absolutely. We're still, what you can expect on finance is delays. Don't sign a contract thinking 42 days finance clause is realistic. It'll drag out. It always does. At the moment, banks are busy, credit's in ascendancy, everyone's looking at a whole lot of detail, and of course we've still got the body corporate approval process to go, as much as that's getting a little bit better. But if we're going to lose a deal, it's going to relate to figures. And the issues are as simple as not having a letting appointment. So hopefully, again, the thing to do, this is back to that deal killers session, is go home, review your verification report when you purchased, see if there's any defects in the letting appointments, fix them. Because the other thing is, if you don't have a letting appointment, you can't charge commission. So I've had 2 clients over my entire management rights career who have rung me, and one was in a holiday building where it was a really high turnover one. So I think at the end of the day, these management rights clients had charged this particular owner near enough to 30 or 40 grand's worth of commission over a couple of years and didn't have a letting appointment at all. And the owner wrote to them and said, okay, you haven't got a 20A, which is what it was at that stage because the rules were the same. I'd like my money back. Client rang me, said, what do I do? I said, you give them the money back. There is no argument about that. It is black and white. So if you are acting for someone without a letting appointment, you need to fix it, because I can guarantee you that the buyer's accountant is going to take the income from that appointment out in the sales process. And if you come back to those known unknowns, It also is an offence from a fair trading perspective to do it, and leaving aside the financial consequence. So imagine if they'd gone to sell in the next 12 months and there's a big 40 grand hit in their P&L. Anyway, one of the other things that we're seeing a lot of is clients not actually signing Form 6s. They send them out, the client comes back signed. What you need to do to close the loop is to sign them and send the buyer or the owner a signed copy. We're having lots, and that's obviously easily fixed, but it's just one less thing to argue about. There are a whole lot of charges, obviously, that go into letting appointments, particularly more so in the short term or short stay buildings. If those aren't accurate, if you haven't entered them right in your software and you've got the charges out of order, percentage commissions, GST, we've got one holiday building at the moment up north where the client's got the mid-stay and end-stay clean charges around wrong in their Form 6, which meant that there's a 20 grand reduction in income that they should be charging. So that's come straight off the net. And I know because the accountant who did that for our client as buyer did it for these guys going out as buyer, and she pointed the same issue out to them when they bought, and they've just done nothing about it. So that's now cost them a substantial sum of money. Leaving aside, if you haven't got it in your Form 6, you can't charge it. So again, that difficult owner who goes and decides they want to take you on because of some perceived slight somewhere and has a look at it, that's the grief that you're going to have purely from an operational perspective, leaving aside from a long-term perspective and from a sale perspective. So these things need to be as clean as a whistle. Now, the other thing that I know we do, when the POA arrived in 2014 now, it's a long time ago, one of the things you need to do after you purchase your management rights business is send a letter to each of the letting owners saying that your appointment has now been assigned to me, here's my details, the same terms and conditions apply, and you've still got the right to terminate on 30 days notice. In summary, there's a specific section of the Act. One of the things we do is we give to our clients, and I'm religious about this, the day of settlement or the day after, here's what you need to do now. Here's the template letters to send to your investor owners, send to your owner occupiers, send to your outside agents, etc., and send to your tenants. And that includes that notice. I think, and I've definitely had it once, we're going to start coming across people that haven't sent those notices out that have purchased since 2014. And that means you've been acting without a letting appointment for that entire time, which could be catastrophic. So if you haven't done that, you need to check it, and that's something you need to deal with straight away, because you don't want to be acting without letting appointments. And ideally for me, that letter is part of your owner's file, because that's what the accountants are going to be looking for. And like I said, there's a whole lot more detail on the Management Rights Deal Killers presentation about letting appointments and the issues with them. You really need to tick those things off. And I say that endlessly because, and this has been an issue for 20 years really. PAMDAs, Form 6s, and for me, some of the accountants go around saying you should change your 20As to Form 6s. I think absolutely not. If they're right, they're right. They transitioned across, there's no need to change them just for the sake of it. But if you've got issues where, for example, you haven't actually assigned them properly, you need to deal with that. So you need to make as a known that you're 100% right on that side of your business, because the consequences, if they're not, can be catastrophic. I bang on endlessly about this too. Tenure. In simple terms, the longer you've got on your management rights agreements, the better off you are, the more secure you are. So again, standard module is 10 years, accommodation module is 25. We run a program reminding clients to top up when they should top up, which from my end in the standard module is at least every 2 years, maybe every one, subject to how big your business is. And from an accommodation module perspective is getting up to 25 whenever you can. So you don't want to let that lapse. You don't want to fall away from it year after year. And I'm in the middle of one at the moment where a client who's been in her business for a long time, more than 10 years, and she drifted along. The agreement got down to 7 years, and then the committee decided they'd have a go. So that has been an 18-month battle. We ended up getting a new management rights agreement literally on the toss of a coin. So that was one where I had to go to the general meeting, had to fight the good fight. There was a motion with alternatives. It was, yes, we want management rights. It was 20 all. Committee's option, our option. Obviously, our option was a whole lot more palatable to us. And so at that stage, it's literally heads or tails. and I called heads and we won. So can't guarantee that every time, but that was handy. But you don't want to put yourself in that position where your body corporate has that sort of leverage. And the other one, which we've had a fair bit of recently, you've got to know when your options are exercised. So you've got a term, 10 years, 25 years, 18 years, whatever it might be. That term is going to be broken down, like lease terms can be, as maybe an initial term and a bunch of options. It can be 5 plus 5 plus 5, 10 plus 15, 15 plus 10, whatever it might be. You need to know what you need to do to bring that additional option term into effect. We've had 3 probably in the last 6 months where clients haven't done that. And I shouldn't say they're clients of ours because our clients get told to do it. I go through the process, I remind them. We're in the middle of one due diligence at the moment where, well, it's not at the moment because the deal's dead. The seller forgot to exercise an option in 2015. And they went for a top-up last year and lost. So they were topping up. Again, you'd say, why did the lawyer top up an agreement that expired? But that's a different question. So that, from a buyer perspective, is dead in the water. So that client's business, or that seller's business, which was 7 figures, you know, it's just a business only in Brisbane, just north of 1, is probably worth 0. So that is the consequence of not exercising options and knowing when they are. Really, really, really important. If you don't know, I can help you with that. But you need to be critical about that. And I know I've just started reminding the clients that we've got to do in January next year to their options. And I've got 50 of them. And I'm pretty religious about this as well. We've got a double backup process. We've got 3 sets of eyes that look at it on the way through, so we make sure it gets captured. I've got 50 of them to do next year for existing clients. Across Queensland, obviously. And you guys will all have that somewhere in your machine. You need to know what that is. So you need to make that exercising of options is just so brutally important, it's not funny. And again, it's very easy to lose that in the middle of a management rights purchase. You don't know. You've got a due diligence report that says it, very easy to forget. And who has a diary through to 2023 today anyway? We're dealing with what we've got for the next 12 months, maybe for the next 2 months. Advisors, yeah, I thought then this is a little bit, for me, you'd call it subjective, a little bit self-serving. It drives me nuts. You know, we are good at what we do. We don't get every person that approaches us to act for them. Sometimes we'll lose jobs for $200, and I know who I'm losing them to, and I know that we will do a much better job, and I know the quality of the work that person's producing, but the clients don't. So that is a battle for me to start to educate people around the difference without death riding the opposition. Because I think the thing for me that the right industry person believes, or the right industry person brings, is that bottom point there, the difference between legal and commercial advice. So again, we go back to our mediation one. I had to drag that client effectively kicking and screaming into that. Believe me, we'll punt this much money on it. This is how it should go. This is the outcome that we should be looking for. And no, it might not happen the day, but it should start the process afterwards. And that happened. So the legal position would be me just listening to the client and saying, no, Frank, we're not doing that. Okay. I'll wait for the remedial action notice and then we'll go down that 18-month journey. The alternative was, no, we really need to do this, and this is why. So for me, and that's probably where I've now got to in my legal career and what we're building our law firm around, is just specialising so much in this stuff that you don't come to us just for that legal, these are the things you can do, these are the things you should do. And this is what you should do, and this is how we should do it. Because lots of lawyers don't actually provide that. We're not qualified to provide that, and that's what experience brings. So it does drive me nuts sometimes seeing people drift off, because I know what's going to happen, particularly if you go and you're just going to have the remedial action fight and all you're going to do is have that fight and you're going to rely on QCAT to decide the outcome, because that's just a horrible way to go. But that's where most people operate. So yes, that is very self-serving, and that's certainly something from a business perspective we're looking to get a whole lot more discipline around, because from our end now, this is all we do. I don't want to be a big multinational law firm with 40,000 staff and offices everywhere, blah, blah, blah. We're based in Brisbane. The technology allows us to operate across Queensland, which we do. And actually sorting these things out is what really the art of law needs to become, as opposed to just serving up, here's the three things. Now again, in terms of the advice I'll give you, it'll be around legal stuff. I'm not going to tell you what your multiplier is. I'm not a valuer. I'm not going to tell you what the net profit is. I'm not an accountant. But in terms of legal strategy and where we should be going, absolutely that's what we do. Caretaking duties. Now I was talking to Scott about this. Now that would be an absolute pain in the backside maintenance program from a management rights perspective. You'd want to be getting $3,000 per lot per annum to deal with that, and probably a degree in horticulture. But from my end again, this is this management rights solving disputes ones. If we're going to have a risk in management rights and we're going to have a dispute, it's going to relate to the performance of the caretaking duties. 95% of the time, that's where they are. The genesis for them might be something else. It might be that we've taken a pot shot at the chairperson, and I still come back to it. My favourite story, had a client, Anne, I'm sorry, who was a school teacher, who, I should say Anne's a long-standing client, so I'm not picking on her personally, who was a school teacher. Chairperson sent out a one-page circular with the AGM, and our client corrected it with red pen and sent it on email to all of the lot owners. So how do you reckon that went? So when we didn't understand what our caretaking duties were and we weren't doing our job and the chairperson decided to read the agreement and then start throwing stones at us, that was not very pretty. So again, picking fights you don't need to is absolutely part of it, but that's where it starts with understanding from my end what your management rights agreements require. Understand your duties, understand the gaps. And talking to Scott before in terms of where REI Master, I mean, we say, mate, you get sort of 2,000 development requests you've got to filter, which all of you guys are obviously contributing to, which is great. Obviously can't do 2,000 of them a year. One of them I think that would be really good, which is absolutely on the list, is helping create some sort of facilities management program / caretaking checklist that you can use for your own purposes to make sure you do what you need to do. So we're certainly moving more towards, in management rights land, more specified schedules of duties, daily, weekly, monthly as required. And for me, that is a good thing. Moving away from mow the lawn as required is a good thing because there is so much grey in those general duties because it's that expectation management piece in between that is the difficult thing. And this is where a known unknown is going to be, we don't know what the body corporate thinks we should be doing. Probably most of them won't have even read the caretaking agreement. All they know is that they're paying you a salary of whatever it is, and what do we get for that? And when we start looking at cutting costs, bodies corporates don't have discretionary spending, they don't go on holidays, they don't buy flowers for their wives, they have statutory obligations, they have contracted commitments, and one of those is the caretaking salary. So there's nowhere to go. They cannot change it unless you agree, but they can absolutely cause grief around duties if we don't manage the expectations right. So from my end, I think the best way to do that is to create your own checklist so you know what it is that you're doing. If your agreement's got that, great. If it doesn't, then create it for yourself. That doesn't mean you need to give it to the body corporate. It doesn't mean that you're going to be accountable to that for them. That's for your own internal purposes. And again, Herb up the back, who hasn't had a holiday in however many number of years, probably because he might be a control freak and doesn't want to let go. I don't know. Far to be assassinate your character, mate. If you do decide to take a break, that is then what you use to get your replacement to know what they need to do. And it also will help you figure out from a management perspective what you need to do, and for the inevitable conversation with your committee at some stage about what is it you do for this 80 grand a year? Well, this is what we do. And for me, the other thing that then will happen is that at some stage, and I'm an advocate for this absolutely, is that when we go to top our agreements up, the inevitable conversation sometimes is around remuneration and the other part is duties. Like for me, the three big things in a management rights agreement are term, duties, remuneration. That's it. The rest of it, I won't say is fluff, but that's legal stuff I can deal with. The commercial things that the body corporate and you need to be happy with are what you're doing, what you get paid for it, and how long that's going to go for. So from a management rights perspective, I'm not frightened to suggest to clients to have a conversation with their body corporate about changing duties, as long as there's a consequential change of remuneration. And I'm the same. You know, I'm happy If you ask me to jump, I will ask how high, but the higher you want me to jump, the more it's going to cost. And that's okay. Having that adult conversation with the body corporate. So if you do have an older style agreement, coming up with a new schedule of duties, tidying up the remuneration, and then adding term, because that's really easy for the body corporate to give away, and really works for you, is the way to do it. So from my end, do that, know what the gaps are, and if you do start to get those little twitchy emails from committee members, or there's that concern about value or whatever it is, that's when you can start to wheel that out for that conversation. And again, that solving disputes presentation had a whole lot more in that about red flags. So you want to know what your duties are, and you want to be ready to manage the committee on them when the time is right. Because the reality is that unless, particularly if you bought a business off the plan, or you've got one of the older style agreements which some lawyer pressed print on and that's what you're still doing, that is not going to reflect the needs of the building today. And to me, that certainty will remove opportunities for disputes. This one, I thought I'd throw in really an advice and recommendations perspective. It's very easy to give off-the-cuff advice, suggestions, comments to committees. And it probably more than anything else applies to strata managers, but I thought I'd put it in there. We get a lot of strata managers who do, and I see it all the time, they sort of give effectively, I've seen what happens here, here's what the body corporate should do. And more often than not, that doesn't take into account all of the circumstances. So despite the fact that it takes you 5 years to get a law degree, I did mine externally, probably through that law degree, maybe 6 months of what I studied is relevant to what I do today, but leaving that aside, strata managers tend to cross lines a lot in terms of giving committee advice about stuff that might be wrong. See it all the time. Sometimes we have to unscramble it, sometimes it's too late. And what you want to do from a resident manager perspective is just to be cautious about what advice you're giving and where. So there's no black and white rules in relation to this. If we're recommending people, we want to have a solid basis for it. If we're presenting choices, we want to make sure we've researched it. It's just one of those little things that can come back to effectively kill trust if you don't manage those things right. So I don't think I've probably got a whole lot more there. I mean, that's not to say you want to be completely passive about it. If the filter's breaking, then obviously understanding what the needs of the pool are, understanding what the options are, researching that, providing 2 quotes and saying, I think this is the one, you guys let me know, is the way to deal with it, as opposed to just serving up the one and making the choice and it's effectively yourself. That's the sort of risk people can run. Disclosure, Old Faithful. You guys have the same relationship with your lot owners that I do in terms of acting for you. What that means is you need to put their interests above yours. So, simple story, we had a bank approach us 1,000 years ago, basically saying, if you refer us loans, we'll pay you trail commission of 0.25. It's like, no, not going to do it. From a legal perspective, it smells. I'm going to put someone forward, leaving aside, I'm not a finance, but it's just way too hard. So in a management rights sense, I think the simple question to ask yourself, if you're not going to disclose that particular circumstance, why not? If not, why not? So if I'm not disclosing that I'm getting a commission from insurance, why not? Well, I don't want the owner to know that that's who I've recommended. No, wrong answer. You need to disclose it. And in fact, you've got a statutory obligation to do so. The other thing is, from a caretaking perspective, it's exactly the same. If you're getting slings and kickbacks from people, and hopefully none of you are doing that, there's one horror story, and I can't believe they did it. Managers put in their P&L 20 grand for painting a building. What's that? Oh, that's the kickback we got from the contractor. And they wanted 5 times on it. It's like, you are joking. That would lose you your management rights agreements. Not a word of a lie. So those things. If you're frightened to disclose it, there's obviously a reason for it, and I can tell you that disclosure cures all evil. You tell people what it is, and for me, it's almost the ethical question. If you've got from a legal perspective, we've got an ethics section at QLS. If I have to ring QLS to ask the question, I really know the answer to the question before I'm asking them. The fact I'm asking them for advice says that there's something going wrong with whatever that particular set of affairs are. So the thing, though, that I think it's easy to forget is there's a little sneaky thing in the code of conduct from a letting agent perspective that if you've got an interest in a lot in your letting pool, you need to disclose that to your investor owners. Gets forgotten all the time. So an interest is you own one of your own properties, you lease back one of the properties. All of your investor owners need to know that you're doing that. Very easy to forget. And that really, for me, is one of those unknown unknowns. Had a client come a cropper on that once, and to be fair to fair trading, they weren't too brutal on it because that client said we didn't know. Well, you've got a code of conduct that says you should know. So at this particular point in time, we require you to do this. And that disclosure is not a statutory form. You can stick it in a newsletter, but you must disclose it. So again, commissions, kickbacks, whatever it is, slings from referring people to real estate agents for selling their properties, all of that is required to be disclosed. 100%. So make sure you do that, because that's... Yep, sure. So this is a clarification around owning and leasing back. So if you've got an interest, and they define interest, well, interest isn't defined, it's interest in a lot in your letting pool. So if you own a lot that you rent out in your letting pool, you need to tell all of your other letting owners that that's what you're doing. And so to me, interest includes leasebacks, it include, well, probably arguably, guaranteed rent situations and those sorts of things. So, because in effect, what it is, that you're competing with the people you're acting for. And of course, the absolute worst thing would be if your unit's 100% and everyone else is 70. That's obviously very brutal. And fair trading is the one time I've seen that pretty red hot on, let's see the occupancy, thanks. So make sure you do that. That's an unknown that's very easy to forget, particularly in short-term rental buildings, because leasebacks can become pretty common. This one I thought of Sunday night and added in. I have lost time or lost count of the number of conversations I've had with clients about why are they doing this. I don't bloody know. So sometimes I think you've almost got to give up trying to understand the idiocy of people. It might have been something you said, it might be something that someone else has done, but usually it's play the man or play the ball, not the man. If you've got a particular set of circumstances and someone's causing you grief, trying to understand why they're doing that might help to a degree, but realistically, more often than not, you've got a legal situation that you need to deal with. You've got to deal with it. There might be some conclusion or solution there if we did know what it is that they're doing, but the more I deal in Strata, and I suppose Airlie's getting used to this now, one of the questions is, what's the average committee member look like? I don't know. Anywhere from 18 to 70, male to female, professional or unprofessional, degree qualified or not. It is a completely random concept in terms of people putting their hand up to say yes. And their motivation to say do that is also really interesting. Some are doing it to get their tiles done in their backyard. Some are doing it to square up with the person that charged them the $20 late fee. Some might be having a crack at the strata manager. Some might be having a crack at you. Some might be doing it just because they're unhinged. You know, you just don't know. So I think probably where I've got to is really, absolutely, if there's someone going spare, trying to understand why is worth it, but I don't lose sleep over that anymore because it's dead set impossible half the time. So that, to a degree, will always remain an unknown, but it's just a matter of recognising that that's the case. And that's my favourite one, as much as I downloaded this. Every village has its idiot, everybody corporate does too. It's just a matter of knowing who that person is, and hopefully it's not you. Now this is another one, and this is something that we see a little bit. Partnerships and employees. So again, subject to the scale of your business, you might or might not have employees. And I think from a CRIS perspective, you can offer fraud insurance here, can't you? Cool. And I'll give you my horror story. We got ripped off by a staff member. And two ways. Our accounts manager, for want of a better phrase, what she was doing was getting geared up for her wedding. She then got all of our credit cards, which she was in control of getting and then putting the GL codes through every month, decided to start putting her wedding expenses on those. And they came through to her and she'd just code them through to whatever it was. So obviously in a law firm, there's lots of marketing and stuff going on. So, you know, the overnight accommodation at Q1 could be someone down there for a seminar or a function, whatever. The other thing, and this is where she mucked it up a little bit, was, again, if we owe $1,000 to Chris for insurance for the year, the way our system works is we see EBM insurance and an amount, click the box, yes. What she was doing was changing Chris's account number to be hers. And of course, we're not checking account numbers. So this went on for 2 months, cost about 30 grand, and really only started to come through when Chris would ring me and say, you haven't paid your insurance. Yes, I have. No, you haven't. Yes, I have. And hang on a minute. So yeah, that was an interesting exercise. You can get insurance for that, and you should. And we now have it. We didn't at the time. And interestingly enough, it was, I'm not a vindictive person unless you really rattle my cage. So for me, it wasn't, she's been stupid, she's only relatively young, I don't want to report it to the coppers. And a detective mate of mine said to me, you have to, because if you don't, she will go through life doing that to the next person, the next person, the next person, the next person. Leopards do not change their spots. Anyway, if she did it, we got the money back from Spur and happy days, and I'm just thankful it wasn't the trust account. So really, the lesson for me in this, and partnerships is the same. Obviously, syndicates or partnerships, they're much bigger in management rights than they were 15 years ago. All of you might have your own business. You might at some stage invest in these things. What you can't assume is that someone else is looking after your investment. You need to keep actively involved in knowing what is going on, because from a partnership perspective, I could be here for the next hour talking about horror stories about partnerships gone wrong and why. And usually it's because everyone is thinking everyone else is watching everyone else and running the business, and no one is running the business. Or the business is being run really badly. Or the partners are helping themselves to 150 grand out of the trust account, which is what I've got with one right now. So we've just this week gone to fair trading and said, we're sorry. We've only just discovered this. And that's, again, long-term family, friends, blah, blah, blah. Doesn't save us from culpability with fair trading, and now we're waiting to see how they go. And the other thing with trust account fraud is you've got to reimburse it straight away. So if it's gone, you've got to put it straight back in so it balances back out. Same rules apply to you as they do to me. So overdrawing your trust account is a horrific set of circumstances. So what you need to do is make sure that there is a system for making sure that things are watched, that you do keep an eye on the accounts, that you don't delegate it and leave it go, because ultimately you've got the most to lose. An employee doesn't have the same skin in the game that you do, doesn't have the same investment that you do, isn't exposed to the same risk that you are. So leaving the control of what could be the single biggest investment in your life in the hands of someone else who could be asleep at the wheel is not what you should be doing. You need to know what's going on. You need to keep an eye on things. And if you don't, the consequences can be very brutal. So again, you need to make what's going on in that business a known, not a known unknown. I hope it's going okay. I get money every month. But what does that mean? How many units have we lost from the rental pool? I mean, a horror story, I go way back, down here on the Gold Coast actually. Up north, clients bought a business in partnership, put an employed manager in there to do it. Really big one, more than 100 units. Basically, it was all, in those days, marketeers sold, back in the Gold Coast in the 90s when you could do that. Basically 100% in the rental pool. 2 years later, they'd lost 30-something units out of the rental pool. And what they'd said to the manager at the start, or the employee, was, yeah, sure, mate, you go sell them. Don't worry. And so the manager was taking listings and flogging them like crazy to owner-occupiers at discounts, because he was collecting the commission. The loss of the units from the rental pool didn't hurt him at all. And so the incentivisation that should have been done there is, A, our clients should have kept an eye on what was going on and probably should have motivated the manager to sell to investors, because then he probably would have found investors rather than owner-occupiers. So yeah, drop that number of units from your rental pool in 2 years and see what happens. So it's those little things that can lead to really bad financial consequences. Now, this is one I thought I'd throw up, because I have to talk quite a few clients off this ledge. They're being nasty, so can I. Don't do it. And the other thing is living in the past and this point scoring stuff. So people make mistakes. Get that? Happens a lot. I've made them. Committee members make them. Body corporate managers make them. in your world, as a management rights owner, picking those fights for the sake of picking fights that don't actually advance your cause are insane. So the most recent example, you know, we had actually another one in North Queensland, I don't know what it is up there at the moment. Very militant, single committee member of 7, treasurer, driving us nuts and leading the rest of the committee on the warpath. You know, the usual 20 emails a day, put up CCTV, looking at our front door to see when we're coming and going, you know, trying to hook it up to our system and killing our bandwidth. And then when we went and taped up the front of the CCTV, called out security, World War III. Anyway, so it's just complete carnage. Again, where do we get to with that? Let's start with what our duties are. He doesn't have anything to have a crack on us from a performance perspective because we're doing our job. So we need to navigate our way through these things, get it back to a stage where hopefully we can find someone else to replace him. And really, and this is a relatively short one, 2 months later he resigned because he knew he had nowhere to go. We'd run him over. So suddenly, it's all calmed down because the chief antagonist is gone. The first thing our client now wants to do is go back and revisit all the minutes and correct all the mistakes that were in the minutes for the last 12 months. And it's like, stop. It doesn't matter. Firstly, no one reads them. It really does. And this guy is gone. And the other thing we're then going to do is potentially put the body corporate manager through a whole bunch of grief because they've been the one that have been taking the minutes ultimately. And the fact that it's in the minutes doesn't make it right. The minutes need to be a record of what occurred. That's what the records do. If that's not what happened, being in the minutes doesn't necessarily make it that way. So in that sense, it doesn't have any legal issue for us going forward. We don't need to cause the strata manager grief. What we need to do, and certainly it's the way I'm built, is we need to look forward. We've got rid of the guy that was causing us the pain. We now need to settle the relationships with all of the owners. We need to tuck our investor owners, and we just get on with doing our job. And this will become a distant memory. And my experience with those ones particularly is that guy will without doubt sell his unit the next 6 months. Because what he's had is his nose rubbed in it from our perspective in terms of he's gone on the warpath and he's completely lost. More often than not, those people sell, so they'll be gone. They don't retire gracefully into the sunset. They take their toys out of the cot and go home. You never see them again. So from my perspective, and what we've done in that one the whole way, and there was absolutely some militant emails beforehand, you've got to remember that every single thing you write may at some stage be before a judge or an adjudicator, and you want to stay professional. So even had a conversation with a committee this week that want me to underline and put in caps and bold a particular sentence in a letter. It's like, no, it's childish. We're not in grade 5, we're adults. They can read, it's telling them what it is, I don't need to emphasise it. When you start to do all that sort of correspondence and you engage over a long period of time, the unknown you're creating is a potential bias at some stage from a decision maker against you and your conduct. Because if you've played the man and not the ball, I should say the girl and not the ball, I shouldn't be gender specific, you will find at some stage someone might turn against you. If these guys, and I say that in a committee sense, look crazy and you look sane, that's a bloody good place to start. And dead set, I reckon half of the reasons committees lose in QCAT in terms of the remedial action notices is some of them are unhinged and no one pulls them up. If they actually behaved like adults, understood the contract, they might actually get further, but they just run off tap, body corporate managers don't pull them up, and they do look crazy. And what you don't want to do is look crazy. And that's where I think, from my perspective, that's part of the EBM insurance stuff in terms of if you're starting to get twisty with your body corporate, don't engage at their level. Stay professional, stay above it. Remember that at some stage someone might see that correspondence and you want to look the way you want to look. And the other thing with correspondence is heat of the moment, stuff you write at 9 o'clock at night is going to be completely different to the stuff you write the next day. So that 24-hour rule is the most important one. Absolutely draft it, put it in your draft items, look at it the next day, see if it even needs to go. I still use that. I'm happy to dictate something now when I'm angry, as much as I don't bother anymore because it just wastes my time. I know that every time the next day I wouldn't write that. So what I do when I get really annoying bits of correspondence, and lawyers are good at doing it to other lawyers, is save it in our system, give myself a task to look at it tomorrow. I don't even read it, because I know it's going to be snarky. And I deal with it the next day. So you guys, from a relationship management and sanity perspective, I think adopting that same approach will make a whole lot of sense. Change, this is simple. Be ready. The pace at which things are changing today is astonishing. And even, I'll give you the latest example we've got in the legal fraternity is fraud, which I'll talk about in a minute. Land Titles Office is getting ahead of potential fraudulent transactions. So if you want to sign a land titles document with us now, you need to bring in 100 points of ID, and I need to eyeball you against that ID, and I need to keep copies of that ID for 7 years. And our professional indemnity insurer has said, here's the certificate you must complete to keep with that ID. And that ID must go with the person who is the witness, because it's not an obligation on the firm, it's an obligation on the witness. So if one of my junior lawyers witnesses your signature, in theory, they've got to have this traipsing around with them for the next 7 years in case the registrar says, I want copies of that. So we've now got to try to manage the security of that information. And you know, the starting point is we're going to do less and less of it. People walking off the street, no. Other people's clients, no. It's another risk that's being thrust upon us to make sure that we're doing these things. And it's a pain in the backside for clients. But here it is. I can sit here and whinge about it, or I can just deal with it. And I think all of you need to be the same. And that's the, you know, law firms or legal industry can be dinosaurs. I think from a management rights perspective, the industry itself, I think, should and will start to upskill and be more professional, because that's who we're competing with. We're competing against, you know, franchise agencies with systems and processes. So the management rights industry as a whole needs to come to that next level. You still have a major competitive advantage by being on site and having personal relationships with your owners, which is what you should do. But there is a lot of change coming. And I don't know, this really is an unknown. We've got the legislative stuff, we're going to be managing people and pets, you know, minor modifications to units, inevitably people claiming domestic violence and leaving on short notice, not to make little of that, but there's the capacity for that system to be gamed really easily. Who knows what technology is around the corner? I suppose this is an issue for you guys, Scott, making sure that with the right platform, you're up to speed with what's going on, you're using as much as you can about the technology solutions that are out there, and competition isn't getting any less. So, and that is the same everywhere. So I think the head in the sand, I'm not going to deal with it approach is not going to keep you going in the long run. You've got to be aware of things, be ready to change with them. And that's a mindset more than anything else. Now this is the last slide, so I hope I haven't gone too long. Every fraudster is a hoodie. I don't know whether that's a boy or a girl. And this stuff is probably the biggest change, I reckon, that the legal industry's seen in the last 12 months, because we have become massive targets for fraud. That verification of identity stuff is part of the response to it. But what was happening there? Because what we do is obviously, from certain times, we deal with large sums of money. Settlements, whatever it might be, you know, the balance of your equity. And what has been happening is hackers are rather hiding in our system, hasn't happened to us yet, touch, or they're hiding in your machine. And so when I email you and say, okay, here's the 450 grand we need for the balance settlement proceeds, can you please put it in my account? Either they send an email from my system pretending to be me, actually I gave you the wrong account, make it this one, or they're in your system and they change the account details to be their account and you don't even know it's happened. And you pay that 450 and it's gone. So at the moment, well, it's probably at certainly April, May this year, the Queensland Law Society would have 2 calls a week with, I think I've just been done. And they are always after lunch, and they are usually later in the week. So and I did a session, one of the things I'm part of is the Australasian College of Strata Lawyers, which is New Zealand and Australian strata lawyers get together we had a conference in Auckland and I did a session on fraud, and really that was just a whole bunch of war stories like the ones I've been giving you today. And there would have been 50 lawyers in the room, and it started very simply is, who has ever been defrauded, had an attempt to be defrauded, or knows someone who has been defrauded? And everyone put their hand up. Every single person. I could rattle off half a dozen mates that this has almost happened to or happened to. Now in management rights, I haven't seen it appear yet. I think we've still probably majorly got employee stuff is probably the major issue. You can insure for cyber fraud, Christopher. You should be doing that. Again, we didn't have that policy. We now do. I had a lawyer mate who got one of those crypto lock things. They hopped in, they came into work to log on one morning, system's locked down, you need to give us whatever it was, Bitcoin. They panicked for a day and then thought, you know what, we'll just go back and get our backup from last night, start again and lose a day's worth of work. And they got around it that way. I had a body corporate manager client whose clearly IT provider was asleep at the wheel, where these guys, or girls again, tried to hack into their system overnight and did it for that long it burned out their server. I don't know how that physically happens. They were attacking, and it just blew up. He was offline for a week. So from a management rights perspective, you need to be alert and alarmed. And I think the one that used to happen in management rights was the advanced fee fraud one, and particularly in short stay buildings. So you'd get the booking for 40 people for 20 nights in a peak period, paid on a credit card, you know, from the Jesuit Society of South Africa. And that would be because someone had scammed the details in some sort of credit card fraud. Then a week later, actually really sorry, we've had to cancel it for whatever reason. Can you please send us back? You've obviously got a fee that you need to keep. Can you send us back the rest? And you send it back, and that was fraud. Haven't seen that for a while. But for me, I think, and talking to the QLS about it before I did this session, the safest way to deal with the potential for fraud is assume that they're in your system. If you do that, you'll react a whole lot differently to every single email you get and every single email instruction. You know, and the first time I had this, I was actually on the golf course with a real estate mate who does lots of big ticket deals, so $200,000-$300,000 deposits, all that sort of stuff. He had a phone call from one of his office admin and got off the phone and said, get this, boys. Office admin had rung him to check whether he'd actually sent an email, which was the deal for whatever it is created. Can you make sure the $200,000 deposit goes back here now? And the only thing that had tipped the admin staff off was it was signed kind regards, which he never uses. But for that fact, that 200 grand would have gone from his trust account to some fraudster inside his system. And they watch the way you work. So where we've got to is that 10 grand or less, they're not going to blow their cover. If you're dealing with us on a transaction, anything more than 10 grand, we will call you to confirm our instructions, or we will call you to confirm your instructions and what you've got to do for us on a number that we know without anything actually happening. We do not operate on email instructions anymore with respect to trust account transfers. Full stop, end of story. So from a management rights perspective, I don't know where that is an unknown, but if you operate on the basis that someone is in your system and is potentially defrauding you, that will change a lot of the ways you work. Then I got one client in Brisbane. I mean, obviously there's been a lot of Chinese buyers off the plan in Brisbane. This is probably one of the early ones. For whatever reason, he had an owner. He had a Form 6, had no bank account details on the Form 6. He had 2 years worth of rent he'd collected without the ability to distribute it to the owner because he could not raise them. And then one day, in walks the young fella who's the son of the dad who owns the property, who's doing uni, and says, oh, Dad sent me in to get this. I look at that now and cringe about the risk that's involved with that. How do we even know who he is? You know what I mean? So it's those things. So I think we all need to be super careful, and that's also, you know, and they're getting more creative. One of the lawyer ones was in a piece of litigation. We're having a blue over 600 grand, been going on for a period of time. Litigation lawyer gets the email from the client, say, you know what, I've had enough of this. If you settle it for 300 and it's done this week, we're done. Lawyer goes through the process, settles it, money's in, paid out, wasn't actually the client. You know what I mean? It's just, it is terrifying. So from my end, be super aware of that, because that is something that inevitably will appear in our industry somewhere. The good news is that you probably don't have, you know, bucket loads of money in trust with rental bonds, forward deposits maybe if you're in short stay. You pay out at the end of every month, which is handy. One client I was aware of, hackers got in their system and for their payroll, changed the bank account details of every staff member to the hackers. They caught that. Imagine if someone did that to you at an end of month. It's it is truly terrifying. So I think for me, I don't have the answer on that one. Have insurance, be alert and very alarmed. And if something doesn't appear normal, or you haven't engaged with this person in a certain way and they're asking you to do something abnormal, double, triple check. And it's very easy to apologise for doing it, because I'm just making real sure this is you. No, it's not the last slide. This, you know, it is easy. The joy of management rights, for me, is the collegiality of it. You're not actually all competing with everyone else. You're all in the same boat. You've all got the same issues. And I mean, even some of the organisations, Kangaroo Point and Tenerife up in Brisbane, have their own little associations, and Tenerife Apartment Managers. I was down signing a client up to a contract actually, and in walks old mate off the street. This is a riverfront building. Mate, you got any two-bedders for rent? What do you want to pay? Oh, this much. Well, no, we've got nothing in that price bracket. What you need to do is go around and see Cliff here, and they've got a little brochure that goes out with all the members. Go around there, he's got that style of product. That collegiality is unreal. And what you need to do from a management rights perspective is make sure you take advantage of that, because you're never alone in this stuff. And this is a little bit emotional. It's not normally my sort of scene, but I do get lots of stressed clients. And usually the reason why is they're in what I'd call, they can't see the forest for the trees. They're getting punched around endlessly by committee, by lot owners. Maybe they've got some issue with fair trading. Whatever their particular issue is, they haven't been able to come up for air and get an independent view on what's going on. And that's certainly what we provide, but it doesn't need to be a legal thing. It's having a network of people in your location, be that beers at the Helensvale Tavern on a Friday night or whatever it is, where you get together and have a natter. It is really important, because life isn't getting any less stressful. I don't think the financial situation that we're in as an economy is going to get any easier. Everyone's still looking for value for money. And if you don't take breaks, this gets worse and worse and worse and worse. So one of the things for me is when I go on holidays, I leave my phone behind, because it's real easy to, I'll just sneak the emails. Stop it. If you're getting away, have a proper mental break. And you need to make sure that you do that. Because if you don't do that, this, you know, can be a 24/7 job. It absolutely can be. And particularly if you're with your partner in the same thing, you don't get any clear air. You need to make sure you do that. You need to make sure you communicate. You need to make sure you go to industry functions, managers to get-togethers, ARAMAs, all that sort of stuff. And you need to have someone you can talk to. And that's, again, my relationship with Cole Myers. As much as he's competition in that sense, I'm happy to sit with him and say, mate, I've got a real issue with handling this. What do you reckon? And he'll ask me the same things for some bits and pieces. So, because we've all got, you know, our unique personalities, we've all got the way we deal with problems. The way not to deal with problems is to lock them down and not address them. And I just am seeing a little bit more of this in clients. So I think it is super important to remember, and particularly when financially things go wrong. You know, we all make mistakes. You go back to the GFC, we've all lost money. I've still got my capital losses winding through the system. I wish I could make some capital gains somewhere. But sometimes it is just time to go. It really is. So it might be, and I recognise that we're at different stages of life, and recreating capital is hard. Getting a job is hard. But sometimes you just need to make the hard decision. So if you go back to that story at the very start, where I said that client that's 500 grand down in that management rights business, she probably wasn't selling at, who knows, 2.5 million because she was going to lose 600. In fact, now she's going to sell at 1.7 and lose everything. So if that had been dealt with at the time, and I know she's been super stressed, and we've now got her back on the right track to just realising it is what it is, there are choices, and certainly from a, before I moved to Brisbane, through the GFC down here, had lots of developer clients who went a couple of them went bankrupt. I have had sort of those very emotional conversations. They all tend to get through it, but sometimes if you can't see the forest for the trees, the consequences mentally can be catastrophic. So you've got to have someone else to talk to. I really find your community, make sure you do that, because everyone has the same issues, everyone has the same problems, and you lose objectivity when you're in that mire. I absolutely know that. You just need to have that voice of reason on the other side of the line that might give you some objectivity that helps you get through whatever that particular issue is. And it might be as simple as dealing with a difficult owner. It might be that simple, but it can really weigh on you. And I suppose the question for me is, if you're waking up at 2 in the morning, that's the sign that you need to do something about it. Certainly is for me. When I'm having those 2 o'clock wake-ups, I've got something going on in my mind and I need to deal with it. And I do. And that's, again, I suppose, effectively almost 30 years worth of practicing law, so you get to know yourself a little bit well. Some of you might be relatively new to management rights, you might be new to business ownership in your own right. So that, for me, is a real warning bell that you need to do something about it. So just don't leave it too long. And ladies and gentlemen, that's me today. So thank you very much for coming. I hope that has created some more knowns for you all. I hope you're not wandering around panicking too much about what I've said, and you'd look realistically, there's some very management rights specific stuff, but I think, like I said at the start, for me, those are the issues I think I'm seeing more across my desk for clients with concerns than anything else. So if they do apply to you, I hope that will help you figure out how to deal with them. So yeah, thank you very much. And now we do free legal advice on anything. Load up.
Hi, Frank. When a committee seeks legal advice on the engagement or changing of a contract, would it be normal for that legal advice to be circulated to all owners in the scheme?
That's better. I was wondering whether it was me. Depends on the committee. They're certainly entitled. Is it near your phone? Hey, that might be it. It depends on the committee of the time and what they want to do. Certainly from my end, probably I wouldn't see too many committees do it. And if we were acting for the body corporate, I wouldn't necessarily be advising them to do it, as much as I don't think I've ever had anyone ask the question of me, on the basis that it can be confusing. You know what I mean? There's, it can be confusing for owners. Owners don't get it. So, and that's also the case when you get, when assignment of management rights might be a restricted issue, which means it's got to go to general meeting for approval. An EGM goes out for asking owners to vote yes or no on an assignment, and they have no idea about their legal obligations. So, depends on your committee, depends on the circumstances. I think it's probably preferable on balance that it doesn't, but if your committee is super engaged about keeping owners informed about the whole of the process, then they may well do it. And then the other thing, I suppose, is that the bulk of owners won't read it anyway, would be my take on it. I think probably a better view would be to say, it's on the portal if you want it, go for your life, but from a committee perspective, where I get to is the committee is there to really negotiate what it is that they think's appropriate, and it's up to the owners for approval. So where we normally get to is we've done a commercial deal that works for the committee and works for the manager, and now it's a chance for owners to approve it. If you've got any questions, let us know.
I was just wondering, with the proposed legislation on pets and that, what happens if you get the cat lady who wants a dozen cats? Is there a stipulation on how many pets are allowed?
Where I get to, and probably that same question to me applies in a body corporate context at the moment with owner-occupiers, I think it comes back to the local authority. So bodies corporates can't impose restrictions on numbers alone. but a restriction of the number of pets based on local authority guidelines would be appropriate. So if you can't have 12 cats in a 50 square metre unit, you can only have one, then that to me would be an appropriate thing. And I suspect the legislation should be consistent with that. I hope it will be, but we'll find out soon.
And also with that, like, you know how your agreement says, you know, the got to be good to your neighbours. What if you how does, as a manager, if you got a barking dog all day, how do you deal with that?
Cool. So let's start owner-occupier in tenant.
Well, either or.
Yeah, well, I think there's different ways to deal with it. So at the moment, if it's a tenant and the tenant's in your rental pool, then I think it's a question of whether it's a breach of the tenancy agreement, whether the owner wants to do something about it. If it's an owner-occupier, it's a question really for the committee. So I suppose from a bylaw enforcement process, as much as a body corporate can't just say no to pets in its own right, they can impose reasonable conditions, and if those conditions are breached to the extent that the pet interferes unreasonably with other people's use and enjoyment, then that's a breach of the bylaws. And there are orders where pets have ordered to be removed because of breaches of those bylaws and those conditions, but it's a question of evidence. So for me, the process is to gather the evidence in terms of a log of barking, recording of barking, and then from a bylaw enforcement process, the committee's got the primary obligation to do it. If they choose not to do it, you as a lot owner can do it. There's a Part B process where you've got to say to the body corporate, this is what is happening, I want you to do it. If they choose not to, then you can actually go and do it off your own bat. So you can, and this is one of the difficulties, and I think people have to be careful what they wish for in a sense with the Commission's office from time to time, because as much as there's a process, it certainly doesn't happen as quickly as anyone wants. But from an access to justice perspective, it's spectacular, because no one else has it. If you go to New South Wales, if you're going to have an argument over pets, you're in NCAT, which is their equivalent of QCAT. And that's the full-blown judicial process, lawyers at 10 paces, tens of thousands of dollars. From a BCCM side of things, run right, you can lodge your own application, the respondent responds, you respond to their response, you get a decision, you're done in 3 or 4 months. So that, as much as that's not perfect, it is much better than any other strata jurisdiction that I'm aware of. And it's a really unique Queensland thing. So short version is, you can do something about it. Ideally, for me, it's better if the committee takes the charge, but you have the opportunity to take the charge of your own right if the committee doesn't do what it wants, what you want it to do. Assuming you've got the evidence. That's the big thing in Commission's application. It's all well and good to say the dog's barking a lot. When, how, recording, all that stuff. My understanding is it'll be done before this term of government, which is 31 October next year. So Mick de Brenny's the Housing Minister. I'm told that it's a little personal wish of his to have it through. So my take is there's a whole lot of window dressing going on now about consultation, and they've probably already got it drafted. So yeah, it'll be, I'd suspect, by June-ish. And I think if you look at it from a pure political perspective, not all owners are voters, but all tenants are voters.
How do you deal with a committee member who is harassing other people in the building and the committee shoves it aside?
Now, other people in the building or you?
No, people around him in a unit complex. People above him, next to him.
Yeah, but not you?
No.
Leave it go. I mean, just the reality is that it's not your job to enforce bylaws. People have rights. From my end, if you want to refer one of the affected people to me, I'll absolutely be able to deal with it. But from a management rights perspective, wouldn't go near it. Really, it's just, and that's that picking the fights you need to component. It's just, it might annoy, their behaviour might annoy you, might absolutely not be right, but I don't think it's in your commercial interest to go and do something about it.
So if a tenant or another owner comes to you with a complaint,
Yep.
and you pass it on to the committee,
Yep.
and then you just say to them, sorry, that like to the person who's complained, you just say to them, well, I've passed it to the committee, there's nothing more I can do.
Absolutely. Yeah, because they're the ultimate decision makers in relation to it. And what you could do is also give them the Commissioner's office number.
Yeah.
So there's a helpline for the Commissioner's office. So again, in terms of that being a unique institution, there's a free call number you can ring and basically ask them what you should do. And they will tell you. It's like ringing the Supreme Court and say, how do I do this? So to me, I'd give them the Commissioner's office number and they will talk them through that bylaw enforcement process, what they can do, refer them to some fact sheets on their website and that sort of stuff. But unless it's directly affecting you, I'd be staying out of it, because what will inevitably happen is the targeting will then turn to you.
Just another question while I'm here. How much information is the committee obliged to pass on to owners in regard to problems in the building, structural, all of that?
Yeah, righto. It's a really interesting thing in the legislation. So normally we work, in Queensland, we've got a caveat emptor system, which means buyer beware, go do your own due diligence. That gets turned on its head in body corporate, where if you're selling a strata property, there's a statutory obligation on you to disclose latent or patent defects in common property. So if there are structural issues and those sorts of things, the sellers have an obligation to disclose that. We absolutely see it from time to time where committees try to shush things up and not put things in minutes and not communicate about what's going on. And that is a recipe for disaster, because at some stage, some committee member's going to get sued for the inevitable special levy loss of value that someone's going to suffer somewhere. So my take is that a diligent committee would absolutely be letting people know what is going on. They would be, and to me, part of that is controlling the message. It's not just we've got structural defects, it's we've got this problem, this is what we've engaged with respect to fixing it, this is the likely time frame, this is the process we're following. That's what they should be doing, because a body corporate has a statutory obligation to keep common property in good repair and condition. So if we own a house, we can let the gutters fall off and the driveway crack and paint fall away and all that sort of stuff. Bodies corporates don't have that same opportunity. They've got to keep things up to speed. So if a committee's ignoring its statutory obligations in terms of knowing there's issues going on and not doing anything about them, then I think that in the long term is a recipe for disaster.
And what's the position of the strata manager, who knows about this, to actually disclose it in a disclosure statement with a sale of a property?
Well, I think the disclosure statement itself doesn't deal with defects. It's in the contract. So when you look at the REIQ unit sales contract, you go through the details page and then there's one page with sort of 4 boxes underneath these bits and pieces. That's where it needs to be disclosed. So the Section 206 is a very statutory form that doesn't deal with those things. And from a strata manager perspective, they're also firstly going to act under the instructions of the committee. And without doubt, I get this all the time, people blame strata managers for bits and pieces. If it's an organisation with any degree of self-preservation, it will have a written advice to the committee on the body corporate records saying this is what you have to do. And if the committee chooses not to do it, then so be it. It wouldn't be the first committee, again, that we give advice to them. We're not doing that. Okay, but don't turn around and blame me when it turns to custard. So yeah, I think they need to deal with it. And the other thing is, from a management rights perspective, it's worth navigating carefully, because at some stage you're going to go to sell, and if there's a whole bunch of defects in the building that haven't been dealt with, that becomes harder for you to sell your business. So your interests are then aligned with the other owners, but I think you'd want to get there by not belting the daylights out of them, but by helping them manage the process. But ignoring it is not the thing to do. Well, I don't think it's your decision as much as it's the committee's. So, absolutely you will. So, I think probably, no. So the bylaws, to me, in a pet situation, should simply say that you can't keep pets in your lot of the common property without the consent of the committee. I'm probably, where we're getting to from a bylaw perspective now is taking the detail out, because the traditional lawyer way to do things is to have 40 million conditions. But the reality is I don't think you can deal with every single contingency. So, and having the conditions in the bylaws itself doesn't actually make them reasonable. What matters is what's reasonable. So, and I mean, we're in the middle of one at the moment with a 2.5 metre python is the pet that's been applied for. Never seen that before. So, I mean, and if I drafted the bylaw, I wouldn't be dealing with snakes. You know what I mean? So, so I think probably where your committee should get to, and this is the danger, not the danger, the reality is that Google is incredible, can a bylaw prohibit pets? You're going to get our newsletter every day of the week. So they impose reasonable conditions. So to me, I think the advice for you to your committee would be, I went to a seminar this morning, I spoke to a Strata lawyer, here's his name if you want advice, but that's fine. But where he thinks it will get to is you're going to have to allow them to keep it, and you can impose reasonable conditions, and whether those conditions extend to keeping the animal out of the barbecue is a bit grey. That's the answer. I don't think so. I think, like something for me like banning glass in a pool area makes complete sense. Banning pets in a pool area, I think the immediate response is why? What's the... Yeah, okay. And I suppose where I get to is the Commissioner's Office will usually not say no on what people might do. They will then remove consent based on what they have done. So if there is poor behaviour, then that's consequential, and that's back to the evidence type thing later on. No worries at all.
We'll finish it up there, but I want to thank Frank again for coming and giving up his valuable time. Hopefully it gave you a great insight. I won't hold you up too long because I'm sure you've got some stuff to go home and check. Make sure you've got your contracts in order. Make sure you're building those relationships with the committee and also your owners. And fix the letting appointments, which is obviously key for your business to have an ongoing tenure. So thanks again for coming today, and have a great Christmas and a Happy New Year. Thanks again.
Thanks, mate. Cheers.